and man, they can go in and do anything they want to those, just as you could. So you need to have one, but make sure you just give it to somebody who you trust. Again, everybody war with that? So they're effective immediately. So if I do power of attorney and I name my brother, who's an artist, as my power of attorney, if I give him a copy of that power of attorney, he can go take it to the bank and Wells Fargo or whatever and do what he wants to with my money. He's like, oh, I need to borrow money from Joley for a month to help pay my rent, or whatever. It's effective, and even if I'm fine, I'm not incapacitated, I'm not disabled, it's still effective. And they're durable, which just means they're still valid if I became disabled or if I became incapacitated, they're durable. It's good to name a backup agent. So I name my brother as my agent and my sister as my backup agent. Because what if my brother's not able to help? So I always try to name 2 people if possible. If my clients don't have 2 individuals they can trust, I don't name a second. I'm not naming somebody just, I only name them if I trust them. And if I have power of attorney and I have assets in another state, my agent can go deal with that asset using that power of attorney. Yes.
Joley, it's durable, but something I learned recently is that upon death, though, of the individual, that financial power of attorney, you think, okay, I can still go ahead and take care of the funeral, whatever, because I have financial power of attorney. When that person dies, that is
right. So it expires when the principal expires. That's kind of how I say it. But yeah, it's no longer any good. So a lot of people, that's something to think about. If you are nearing a situation, a lot of times people don't have any time to plan. Sometimes people do, and they're like, okay, funeral's going to cost this much money. I'm not going to be able to access these funds if something happens. How are we going to pay for that? So that's something people need to think about. Just because you have power of attorney doesn't mean everything's going to be hunky-dory if something happens, because that's nobody cares anymore. Your power of attorney. If that's nice, it doesn't matter now. If a bank tries to say, oh, we need the original power of attorney, there's a statute that says no, a photocopy is just as good, so they can't require that. They like to require that, they can't require that. So that's that. And then with the financial power of attorney, there are a few things, broad categories of what the agent can deal with on your behalf. Now, in some cases, I've done what's called a limited or a specific power of attorney. If it was just for, I need someone to help with the refinance of my house, and I'm in the hospital and these documents need to be signed and I can't go sign them, then I'll make it very, very narrow. Normally, they're very broad, so the agent can do any number of things. This right here is very important, gifting, and a lot of powers of attorney I see people say, oh, I already have my documents and I read them. A lot of times they're fine. Sometimes they'll have language in there that says, my agent can only gift away a certain amount of money up to the IRS tax exclusion for federal gift tax, say here. Well, that's $14,000, okay? If I'm trying to get somebody on Medicaid and they have dementia and they can't sign anything anymore, and their power of attorney can only give away $14,000, and they have more than that, we have a problem because I need to move assets around, and the agent has no authority to do anything more than $14,000.
Is gifting not part of 5 years look back?
The gifting is part of the 5 years look back, but there are certain gifts that are exempt. And in Virginia, the power of attorney has to expressly say that unlimited gifting is okay for it to be allowed. You can say, you can write your power of attorney, my agent has all authority under the sun, period. It's very broad. They still can't give away more than $14,000 because there's a statute that says you have to expressly say they have unlimited gifting.
Joley, is
Yeah.
that 14,000 per person?
14,000 per person. Yes. So unlimited gifting. What's that? A year. But if I'm trying to get someone on Medicaid, I don't have time to wait till next year to get my other you know.
Release on the 31st, you can also do it in January.
Yes. Yeah. Other language that's really useful is the ability to create trust, and specifically irrevocable trust. A lot of my powers of attorney I see say you can create a revocable trust. Well, if I'm trying to get someone on Medicaid, that doesn't really help me, so I need to have it where the agent can create an irrevocable trust. But the power of attorney should expressly say this revokes any prior power of attorney. That way you don't have more people acting than you want to or have authority. And I found that a lot of times if the spouse's power of attorney or the daughter or son's power of attorney, we might be able to shelter assets by paying them. Like I have a daughter who's power of attorney for her dad. She's looking after him. For Medicaid purposes, I could pay her to look after him. But sometimes powers of attorney are written to where the agent can't benefit. Well, that's benefiting her. So, that would prevent us from being able to do that in that case. So it's important to be able for the agent to benefit if it's in the best interest of the principal. That language should be in there. And the power of attorney, if I give someone my power of attorney, they don't have any legal obligation to do anything. They can sit there and say, I'm not helping you, not doing anything wrong. They have no duty to act. So I could be, hard pressed and really need them, they have no duty. But if they begin to act, they have to do so in my best interest. Okay? And they can't say, well, I'm going to, sometimes powers of attorney agents do not always use the money for the principal. Principal's in a nursing home, and I'll see all these bank statements where someone went and got their nails done or whatever, and I'm just like, no, that's not how that money is supposed to be used. The agent is never liable for any contract they make or anything they do as power of attorney unless unless they're acting with negligence or in bad faith for the principal. And they have used the authority that they were given. So, power of attorney, I think someone that's trustworthy, is competent, is willing to help if you need them. In Virginia, a lot of times my clients think the agent has to sign it. That's not required. When I lived in Pennsylvania, they did have to sign it. But in Virginia, the agent, if you name your son or daughter, they don't sign power of attorney. Just you. You're the only one that signs it. So it's very important that you use someone you trust. I think I said that. Okay. What happens if you get divorced? Divorce voids the power of attorney. If you're separated, filing for divorce terminates it, but living apart does not. But if you say, I name my sister-in-law to be my backup agent, if you get divorced, well, that in-law still has authority. So that's why it's always good to review your documents if you have something like a divorce. If you have a power of attorney and the person's misusing it, or you decide you don't really want the person to have it anymore, you can revoke it in a variety of ways. You can tear it up. You can have a paper that says revocation of power of attorney and sign it. You can create a new one and have the new one say I revoke any prior one. Just make sure you communicate that revocation to the agent and to your financial institutions. And as I mentioned earlier, it does terminate when you pass away. So whoever you name no longer has any authority after you pass away. Any questions about powers of attorney? Medical directive. So this is the document that's akin to power of attorney, but it's for healthcare decisions. And get the same terminology of principal and agent. It's effective immediately. However, the agent can only consent to treatment on your behalf if you're not able to make an informed decision. So if I give my brother my advanced medical directive and I say, well, you're my agent, we go to the doctor and I have surgery, the doctor says, Joley, do you want X, Y, or Z? And I'm like, no, I don't want that, but I'm fine and I'm capable of making an informed decision, competent. Then my brother can't say, oh yeah, I think we should do that, because he has no authority to trump what I said, because I'm still competent. So, but he would have authority to talk to my doctors, to access my medical records, and that sort of thing. But you still have the say, so long as you're able to make an informed decision. Okay. You should have backup if possible. Again, they're called, sometimes people think of them as a healthcare power of attorney or a healthcare proxy. I'm sure y'all heard of a term called a living will. I don't know why whoever came up with that name, it's not really even relevant to what it does. Will talks about, like, I have this and I want to leave it to this person. A living will is if I'm in a terminal condition or I'm in a vegetative state, do I want artificial hydration or nutrition and that sort of thing? That's the living will, the language of that. And that is included in my medical directive. It's a paragraph in there that expresses what that person would like to have happen. So it doesn't have anything to do with what wills have to do with. But it's useful because I think it's really hard for family members who are in a very tough situation to say, do we pull the plug, do we not, do we feed, and all of that, because they feel like it's on them to make a decision. But if you have a parent that has already stated what they wanted in writing, then you're just carrying out what they would do. And so it gives a lot of solace to that person. So a lot of these documents you're doing for you, but you're also doing for your family because you love them and you want to make things easier on them. They're durable, they're valid in any state. If I traveled and needed someone, you know, if it was in an accident or whatever, needed to go to the hospital, my brother could still help with you know, my healthcare decisions there. And a photocopy is just as good. And you should give one to your healthcare providers. I think I said that. Yes, you do.
And going back to your example, your brother is your medical directive. You say no to this procedure and you're still able. Your brother says yes. Who makes the determination and how as to your capacity?
Well,
And that, you know,
as to my capacity.
your capacity.
My capacity. So a doctor, it would be, I'm unable to make an informed decision as per a physician.
Okay.
So a physician would be the one to make that call. Yeah, it's like my brother saying, no, she's not right, you know, because he says that now, and I'm not, I think. So, no, it's different, because that's guardianship and all of that.
Yeah.
So this is by a physician. I've been deemed unable to make a full decision by a physician. Okay, so that's what I just said. And here are all the things that an agent can do. They can admit me to a hospital. This is all if I'm not able to admit myself. Admit me to a hospital, to a nursing home, consent to treatment, x-ray, that sort of thing. So it's really useful for people. I had a family who was 3 sisters, and one of them was unmarried, so she never did these. And the sisters were just kept in the dark by the healthcare providers. Weren't told. I was like, what happened? Why is she in this condition? They're like, we don't know, because the doctors won't talk to us. And they won't. And so we could file for guardianship because, which is, you know, I'll talk about that in a minute, which sometimes people have to do if they don't have these documents in place. These documents do not take a long time to do. You do them, you put them away, and they're done. And it makes things so much easier on your family later. There's no need to have to go through that. Similarly, there's no requirement to act. If they do so, they act in your best interest. If you revoke the medical directive, or give a new medical directive and someone conceals it and acts fraudulently, there's going to be some criminal liability there if they're found guilty of that. If you want to revoke it, you can revoke it these ways: sign it, say it, destroy it, communicate it to your former agent, communicate it to your healthcare provider. That's required.